podcast on the Boss Up Houston Network. Come get your questions answered. We'll see you then. And remember, lawyer up. Hey, welcome everybody. You know what this means. It's Friday. Thank goodness it's Friday. You are on with me, Steve Okoraha, on the Lawyer Up with Steve-O podcast on the Boss Up Houston Network. And like every Friday, we got some great information for you. Thank you so much for joining us. This is the 8th episode of our series. Hopefully I counted that right. You can go back and check on my past episodes and see all the good content I bring in. Hopefully, with as many episodes that have been done, you've learned something, and that's really my goal. So, again, I always want to address the people that are just joining me for the first time. What is this show about? It is a show basically to keep you out of trouble. But on a serious note, it's to give you a lot of different legal tips and things that you can do that can help you in everyday life and help you avoid, a lot of legal pitfalls. So that's what I try to do with this show, and hopefully I have helped as many people as I can. Those that are watching, pass this on to people that are going through these issues. Definitely want to make sure that everyone is well informed and well protected in every situation that they have. So, brief intro on me. If you don't know who I am, my name is Steve Okoraha. I've been practicing for over 8 years. I'm an attorney, licensed in the state of Texas, and I practice primarily in Harris and Fort Bend County. I practice anywhere in the state of Texas, so it's just those two main counties that I practice in mostly. I do business and contracts. Primarily, I do family law. I do some estate planning, and I do traffic tickets with a little bit of personal injury and immigration. But as those that keep watching may know, that I talk about a lot of different topics, and I'm well versed on a lot of other types of law as well. But that's just mainly what I do in my practice. So today we will be talking about a very unfortunate situation. It's the situation of you being evicted and being told that you have to leave your home. Now, hopefully most of you have not encountered this, but it is definitely possible. And, I want to take you through a little bit of the laws and the ins and outs of what can happen during an eviction. So the first part about this topic, we are going to talk about breaking a lease without losing your security deposit. For the second part, we'll talk about repairs and maintenance and what your landlord's duties are. Then for the third part, we'll discuss the actual eviction process and what your best practices are going to be. Now, I am only going to focus on the tenant side of things in a residential context. I will touch a little bit on commercial renting and a little bit on the landlord side of things, because there are two sides, and that's what landlord-tenant law is all about. It's there's rights on the tenant side, there's rights for the landlord side. So for those of you that are landlords or have investment properties or rental properties that you're wanting to help manage a little bit better, or at least be well versed about it, we can definitely talk about more of the landlord duties offline. So that is what our show is going to be about. Stay tuned. We have a lot more coming up, and we have our first commercial break. We got to pay some bills, so we will be right back.
Wanna be a boss? You're watching Boss Up Houston Network. It's Boss Up Houston, where we look up, stay up, and boss up.
Hello, welcome back. Thanks for joining us. Like I said, this is the Lawyer Up with Steve podcast, and we are back to talk about evictions. So, Like I said before the commercial break, the first part we're going to talk about is breaking your lease while keeping your security deposit. The biggest question that I get is, Steve, how can I break my lease and still retain my security deposit? Now, it is different situations where that might be applicable. It's not all the time that you can do that, but I'm going to talk about in general what are the reasons why you can keep your security deposit and what is the landlord's duty in terms of keeping the security deposit and returning it back to you. So, just a breakdown on security deposits. They are obtained primarily to secure performance of a lease, which means it can be applied to non-payment of rent in some circumstances, and it can be applied to repairs that need to be made after leaving the home. So if you put that hole in the wall and you never fixed it, and they go in and inspect it, they see it, the costs for them to repair that hole come out of that security deposit. If you leave trash, if you leave appliances, anything that is something that they have to incur an expense to rectify, then that typically can be deducted from your security deposit. Now, the landlord themselves are liable for what these are things that they can be liable for if they are keeping your security deposit. Withholding a security deposit in bad faith, which is punishable with a fine of $100, 3 times the portion of the deposit wrongfully withheld, and the tenant's reasonable attorney fees in a suit to recover the deposit. Now, what does that mean? That means if in instances that the landlord is withholding your security deposit and they do not give you an itemized list of things that they are using that security deposit for, or it is not for past due rent, then their fine could be up to 3 times the portion of the deposit that they're wrongfully withholding, which means if they gave you part of it back, but they didn't give you the disputed amount that you're arguing about back, 3 times that amount plus $100, and then your attorney's fees that you incur to do that. So if you come and hire somebody like me, you can possibly get those fees paid, and that comes out of the landlord's pocket. Now, if the landlord, again, in bad faith, does not provide a written description and itemized list of damages and charges, they forfeit the right to withhold any portion of the security deposit or to bring suit against the tenant for damages to the premises. And they are liable for the tenant's reasonable attorney's fees, like I said before, to recover the deposit. And in an action brought by the tenant, the landlord has the burden of proving that the retention of any portion of that security deposit is reasonable. So, you leave the home, your apartment, condo, house, wherever, and the landlord decides to keep part of your security deposit or all of your security deposit. They have to show you exactly what the security deposit is being applied towards. If they do not, then that is something that they are wrongfully withholding. You can go after them for that. So, and I know you've been hearing me say in bad faith a couple of times. Let me go ahead and define that for you guys. Bad faith is when a landlord who fails to either return a security deposit or to provide a written description and itemization of deductions on or before the 30th day after the date the tenant surrenders possession, and they are presumed to have acted in bad faith. So, after you move out, 30 days after that, your landlord is supposed to give you your security deposit back. Granted, there aren't any damages in the home. Now, most landlords will wait a few days and say, okay, well, next week I'll come in and do a check, or they may wait a couple of weeks, but they do have a full 30 days to be able to either give you your security deposit back, or they are supposed to give you an itemized list of exactly what your security deposit is being withheld for. So that's just something to remember in case you end up leaving your apartment and you're like, Steve, I don't have my security deposit back. How long are they supposed to take? It's 30 days. So just remember that in terms of when you're trying to move out of your apartment or your condo or your house. Make sure that your landlord is being on top of things and giving you an itemized list of what exactly they're keeping the security deposit for, and also make sure that those things are actually legitimate. You have a right to go back in the premises and to see those things that have been done. They can't just say there's a hole in the wall and you've never put a hole in the wall. You don't have kids, you don't have animals, you didn't fight in there, you didn't party in there, or anything that would cause those damages. So you have to have them show you exactly what those are. So all right, so we will come back with our next segment. We will be talking about repairs and maintenance, so we'll be right back with that.
Breakfast at Auntie D's, take one. That's all it's gonna take.
Rick and Daddy's on the beat.
Wine, dime, kill it time. Heard it through the grapevine. You the type of kid that like to get dime anytime. Wine, dime, kill it time. Heard it through the grapevine. You the type of kid that like to get dime anytime. Wine, dime, kill it time. Heard it through the grapevine. And you the type of kid that like to get dime anytime. Gun, please sipper, Moet, Patron sipper. Do you the type of girl that like to pull down the zipper?
I like your shoes.
Etouffee, appetizer. After this, I'm digging your thighs. Real debonair's eyes. Look in your eyes. You gotta smirk upon your
Go sit down, baby. Go sit down.
and I'm impressed with your waist, petite shape in your thigh. Compliment you on your booty and your hair and your booty. Hey.
Here you go, baby.
Wine, dine, kill the time. Heard it through the grapevine. And you the type of dude that like to get down anytime. Comfort zone when you
Stay up. Where we look up, stay up.
Welcome back, everybody. We're going to jump right into our next segment. We are discussing evictions. The name of this show is "You Don't Have to Go Home." You know the rest of what that statement means. So the next part of what we will be talking about is repairs and maintenance and what the landlord's duties are. So first part about this is that you have rights as a renter. What are those rights? Is you have the right to quiet enjoyment of the premises, which means you can't have any evictions without cause, and the landlord cannot interrupt utilities except for repairs, emergency, or construction. So if there's any type of noises going on, you have a right to let the landlord know that you don't want that to happen unless they're making repairs, and sometimes that happens as well. The next right you have is for health and safety. Landlord must repair any condition that materially affects your health and your safety. And they do not have to repair normal wear and tear. And they must, of course, install any type of smoke detectors, locks on the doors, things of that nature. So if there's mold in your home, the landlord has to take care of that. If there are termites, bed bugs, anything that was in there, in the walls, things coming in, they have the duty to make sure that they take care of that. Now, you can't just have a dirty place and then you get a couple of ants and roaches and you want the landlord to take care of that. Well, that's something that's more of you the landlord may not necessarily, in some instances, but may not necessarily be liable to take care of that. And of course, like I mentioned a little bit before, security devices, window latches, key deadbolts on doors, they do not have to provide you with a security system. However, I do see a lot of newer apartment complexes springing up in the Houston area that do already have security systems within them. So for the most part, you may not have to worry about that. If you're in individual condos, that's when you'll have to look into getting a security system. I definitely recommend it. You can't be too careful wherever you live, in the suburbs or in the city. So that's just something you have to check on if you do decide to rent. Now, we're going to go into a little bit of what happens when you are requesting repairs and kind of that whole process. So let's say my my garbage disposal doesn't work, and I really need that garbage disposal because my sink gets backed up and a lot of things don't happen, and that really, let's just say it really affects my health and safety in that home. Well, I have three different options. If I've requested the landlord to fix it, I've sent them a certified letter, return receipt requested, to make these repairs, and I've given them a reasonable amount of time to do so. I have three things that I can do to rectify that. One, I can end the lease. Now, this wouldn't be my first option because I want to give the landlord some time in order to at least acknowledge that they've received the letter. If they don't, then I can go ahead and constructively end the lease. Move out if it is that much of a burden, which, now that I think about it, the sink, the garbage disposal, the example is not the best one. Let's say bed bugs. I think that's probably a more serious one because I have had clients that have had bed bugs and they've asked the landlord to take care of it. They did not, and they actually had to move out of their home and they were displaced and they had to go to an extended stay hotel. And the landlord in that instance did not show that they made any attempts to try to fix it, although they had been informed of those bed bugs. So they are responsible for the costs of them having to move out and the hotel bills and everything. So that is always an option. Just end the lease. Second thing is that if I were to have the bed bugs and I really wanted the problem repaired, I could have the repairs done, or the fumigation, or calling the exterminators to come in and take care of it, do it myself, and then deduct that from my next month's rent. Now, that is something that you definitely have the opportunity to do. I have seen a lot of people do that in some instances, depending on the severity of what it is that you need and that you are not able to get repaired by the landlord. So that is option number 2. Option number 3, you can file a lawsuit to force the landlord to make those changes. If they're not responding, if it may not be an issue that is going to take you out of your home, but you know that this is something that they are supposed to take care of, or they said they would take care of it and they didn't, you can go ahead and file a claim in court to go ahead and have that done for you. So those are your 3 options for trying to get repairs and maintenance done. Remember, usually within your lease it has all the different things that are things that the landlord is responsible for doing. But just remember, quiet enjoyment, health and safety, and security. Those are your main rights as a renter when you are renting in an apartment complex, a condo, or a home. So what we're going to do now is we're going to go to a very quick commercial break, and then we're going to talk about the eviction process, which can be kind of scary, but I'm going to take you through it. I'm going to hold your hand through it. We'll be right back. A little quick break just to give you guys a chance to digest and really soak up what I'm giving you. Hopefully I'm giving you some information that can help you, or a loved one, or a friend, or an acquaintance, or maybe someone you don't like. you may want to help them too. They may help you in the future. You never know. So let's get into the eviction process now. Real quick, we have a lot of things going on in the world today, but the main thing that everybody is concerned about is COVID-19. So on Friday, September 4th of this year, a federal moratorium, which means a temporary ban, on evictions took effect. In that order, the CDC, the Centers for Disease Control and Prevention, concluded that this temporary ban on evictions would be a way to prevent the spread of COVID-19. This moratorium is applicable only for evictions due to non-payment of rent and is not valid for other lease violations. So, what does that mean? I mean, it means just what it says. As of right now, there is a ban on evictions in residential homes for non-payment of rent. Specifically non-payment of rent, because of course everyone has been having a tough time economically. There's a lot of unemployment. Everyone's not able to make the same income as they were before. That's just the story of 2020. So this was instituted to allow people to stay in their homes longer. But not only that, the CDC ruled that a lot of the people getting pushed out were lower income folks, and those lower income folks were the ones that are more likely in a lot of areas of the country to be carriers and spread COVID-19. Now, I don't know the exact facts on that. You can definitely check it out, Google it. But this is good news for those that are not able to pay their rent because financially they are unable to. Now, if you break your lease for other reasons, you throw a loud party, you blow up a portion of your home, you can still be evicted for those things. The only way this applies is for non-payment of rent. So don't think you can just go crazy and do whatever you want and, flip your landlord the finger and do whatever. You can't do that. Slow down. It's only for non-payment of rent. So let's actually go through exactly what the eviction process is so that you guys know what it's all about, and hopefully you don't have to go through it. And if you're going through it now, hopefully this helps you. So first step is the landlord must give you a notice to vacate. They must give that to you at least 3 days before they can file an eviction suit. So you get to your door and you see that pretty red or pink or fluorescent colored form that states that you must leave in 3 days. They can give it to someone that lives in the home. They don't necessarily have to give it to you. But that person has to be over the age of 16. So they can also affix it to your door. Like I said, they can also put the notice inside of a main entry door. They can mail it to you, regular mail, certified mail, or registered mail with return receipt. And if the rental does not have a mailbox and there are things that would prevent the landlord from attaching the notice inside of the main entrance, such as a keyless security system or a dangerous animal, they can put it on the outside of the main entrance once it has been sealed in an envelope with an appropriate marking, and they also mail it on the same day. So these are kind of the rules of how they have to notify you that you are given this notice to vacate. A lot of times I've had clients come and tell me, well, they never told me that I had to vacate. I just got a notice in the mail that served me with an eviction. Well, more than likely you didn't see it, or more than likely they did not post it properly. So it's really one or the other. So make sure you're keeping your eyes out. And for the most part, if you're given a notice to vacate, you should know a little bit something about what it's for. The most common, of course, is non-payment of rent. That's just one of the many things you can be evicted for. So the eviction lawsuit. So the eviction hearing cannot take place for at least 10 days after the petition is filed. And you must be informed of the trial at least 6 days before it happens. So when an eviction is filed, you have 10 days to go to your landlord, try to rectify whatever the situation is so that they can pass on going to trial. Minimum of 10 days, and then after those 10 days is when the actual hearing can be scheduled, and then you have to be informed 6 days before it happens. So before the actual hearing happens, you have to have at least 6 days notice so that you can go ahead and respond, file an answer, get an attorney, lawyer up with me. So it's just one of those things you gotta get ready for whenever you have an eviction suit filed against you. Step 3, the judgment. Once a judgment has been issued, no further action can take place for 5 days to give the parties opportunity to appeal. Now that's both sides. The landlord can lose too. It's not always that an eviction lawsuit goes through for the landlord and they win. Sometimes you win as well. Sometimes the landlord's not able to provide enough evidence for the reasoning for them wanting to do the eviction. But for both sides, even if you lose, you get 5 days to appeal, and that's just giving people more time to go through the legal process and get justice to be served. Option 4, which is completely optional, you can appeal. If the tenant files an appeal, the hearing cannot take place for at least 8 days. Again, they're giving you a lot of different time frames in order for you to prepare yourself. I mean, evictions and eviction cases run rather quickly. It happens pretty fast. Of all the different court cases that I have, this and traffic cases are probably the ones that happen somewhat quickly. Evictions happen pretty quickly, pretty regularly, because their dockets are usually filled with eviction cases. So hearing can't take place for at least 8 days once the appeal is filed. It's almost like a new notice. And then step 5 was the writ of possession. Once there's a final judgment, the landlord can ask the judge for what's called a writ of possession. The constable must post a 24-hour notice before executing the writ and removing your property from the rental. So what does that mean, Steve? That means if the landlord prevails against you, you have to have a constable come out and post a 24-hour notice before your landlord is able to now go into your property and get rid of all your stuff. They can do whatever they want with it. They can throw it out on the street, they can keep it, they can sell it, but that gives you enough time to be able to remove everything out of there. And I know 24 hours may not be long enough for those of you that have a lot of stuff. I know I have a lot of stuff. That would be a terrible situation for me, but that's just what the law says. So now you know what happens during an eviction. Now hopefully you're better prepared for what happens if you're going through it. Definitely hope this helps you if you're going through something like that now, or you know someone that's going through something like that now. Feel free to give me a call. We're going to go through and give you last few minute tips, and of course my contact information so that you can call me. Let's take a quick commercial break, pay some bills, and we will be right back.
Wow, that's real.
We break the silence.
Gun violence. Trauma feels so lonely.
We break barriers.
I opened that door to drinking after almost 20 years.
We break it down.
It hit me how fragile parenting is.
You're really a great father. And we're always ready for a breakthrough.
I feel like there was a lot of anger.
I needed to be bigger.
New episodes and so many new conversations.
Red Table Talk.
Premieres September 28th
on Facebook Watch.
Everybody, welcome back. Hopefully you have learned quite a bit about the eviction process. Like the title says, you don't have to go home, but I mean, hopefully you can figure out what you got to do and get to where you need to be, and hopefully you're not evicted. So I hope that I gave you some tips that you can help yourself with. But I have a few more tips. You know, I'm very giving. This is the December, so it's Christmas season. So I want to give you as much tips as possible. I'm gonna give you a little bit more. These last minute tips. First one is form a good relationship with your management company. If you're in an apartment complex and you have facility managers and things of that nature, make sure that you have a good relationship with them, because you never know. They may give you, you know, I wouldn't say they give you certain preferential treatment, but they will be more ready and willing to help you in whatever situation and make accommodations for you. It's definitely important for instances where you may fall behind rent, or you may have an extra guest after hours or over the weekend that you did not put on your lease, or maybe that you have that one relative that just won't leave your place for months and months. Maybe there might be something that they'll give you an allowance for, or they'll look the other way, just depending on what type of relationship you have with them. So form a good relationship with your management. 2, don't be rude to your landlord. Your landlord has, even though sometimes it doesn't seem like it, they have a tough job of making sure that they are managing that property and maybe some other properties. So don't be rude to them. Just make sure you're courteous to them. I'm not saying be best friends with them, take them out for drinks. I'm not saying that at all, but you know, just make sure that you have a very cordial and pleasant relationship with them. It makes things a lot easier. The next thing, and this is something that I've personally had issues with in the past when I used to rent. HOAs can be a hassle, big hassle. So if you're in a residential area where there is an HOA, get familiar with your rule book, because a lot of times HOAs may come up with different rules and regulations that are not in that rule book that they will try to enforce against you. You may just be minding your business, trying to do something, and then they say, hey, you can't do that, and you're like, well, that's not in the rule book, and then they give you a fine, or they tell your landlord, they give your landlord a fine. A lot of different things can happen. So definitely make sure you get familiar with the rules and regulations of your apartment complex or your neighborhood, and anything that the HOA may prescribe to you. And last but certainly not least, and the most important, and this is what I tell everyone, even in a non-landlord-tenant context, read your contracts, read your lease agreements, read addendums, read everything. Make sure you understand word for word what everything means. Do not be afraid to speak up and ask questions. And if you truly don't understand and it's overwhelming for you, get an attorney, give me a call. I can help interpret things for you and maybe negotiate certain things for you if you don't like it. The biggest thing people forget, because you know they're in a bidding war with other people trying to get this pretty house or this pretty condo or this pretty apartment, and then you just sign all the documents and then you just say, hey, I just want to move in, I want to put up my couch and my TV. You may be signing some things that may be disadvantageous to you in the future, and you want to make sure that you understand it before you get into it and not be caught up in a situation where you're at odds with your landlord or your management company. So read your contract. Read before signing. Very important. All right. So those are my last minute tips. Like I said, hopefully this has been useful for you. I also have a lot of these. It's called the Tenants' Rights Handbook. This was given to us by the State Bar of Texas. Most lawyers know about it. They have some. I have quite a bit of copies in my office. You can definitely give me a call, send me a message, and I will send one to you free of charge, or you can come pick it up actually. This is basically your Bible when it comes to tenants' rights, and lets you know all of the different laws and regulations, what the tenants' rights are, what your landlord's rights are, what you can do in any type of situation. Highly recommended for any renter. So in case you need to reach me to get one of these, or just ask questions about landlord-tenant law or any other type of law that I have talked about in the past or today, my email is contact@goodmanmcgill.com. My phone number is 833-529-9748. My website is www.goodmanmcgill.com. And as usual, I'm on Facebook, Instagram, Twitter, and LinkedIn. So you have all of the ways to reach me, and you can send me a message. You can tell me if you like the show. You can tell me if you hated the show. I will accept both sides. I am open to all types of criticism. So, and then of course, remember, when life gets you down, remember to lawyer up. All right, thank you, everybody. We'll see you next week.